One of the best known asset protection tools in the state of Florida is Tenancy by Entireties. Hi, my name is Jonathan Alper and I'm an asset protection attorney in Orlando, Florida. So what is Tenancy by Entireties? Tenancy by Entireties, otherwise known as T by E, is a concept from English common law, and it refers to any property that's jointly owned by a husband and wife where there are rights of survivorship. In other words, jointly owned property where the property will go to the surviving spouse upon the first death. The asset protection rule is that all tenancy by entireties property is protected or immune from the judgments against any one of the spouses. So for example, if there's a judgment or creditor of the wife or the husband, all the jointly owned T by E property is immune from that judgment creditor. There are some rules about how to form tenancy by entireties property. First of all, it's important that you do not do something to disclaim or destroy this ownership. There are some cases where, for example, when husband and wife opened a bank account or financial account, they affirmatively checked a box that said they wanted to own the property in some other manner, like tenants in common. As long as you don't affirmatively disclaim or destroy the entireties, any of your joint property will be considered to be T by E. Remember too, that this only protects against individual creditors. If there are any joint creditors against a husband and wife, the tenants by entireties property is not protected. There are some pitfalls or mistakes that people commonly make when they think they're getting T by E protection. And I'm going to discuss just two of these today. The first rule is that the husband and wife have to be married when they acquire the property. So for example, if Mr. Jones and Mrs. Jones open a joint account while they're dating before the marriage, and then they get married, the property is not tenancy by entireties because it was not acquired during the marriage. The second pitfall is that both of the spouses have to get the property at the same time. Example, Mr. Jones, while he's married, opens a bank account in his own name. Later he decides that he wants to have the account owned by the entireties, so he takes his wife to the bank and adds his wife to the existing account. Now all this took place during the marriage. The problem is that Mr. and Mrs. Jones didn't have their name or add their name to the account together at the same time, and this will cause them to lose the entireties protection. Remember, in the event of a divorce, the entireties is broken, there's no marriage, so the property immediately becomes vulnerable to the creditor of the individual spouse. And if either of the spouses die, again, the entireties concept is broken and the property will become vulnerable. Also, bankruptcy has its own rules, and the entireties protection of bankruptcy is not as good or extensive as it is outside of bankruptcy. If you have any questions about using entireties ownership to plan your asset protection, or if you have questions to make sure that your property is actually owned by the entireties, give me a call. Again, my name is Jonathan Alper, and my phone number is 407-444-0404. And thanks for watching.